No, sir, I have taken consent from other side. I beg to mention item number 10, although it's a fixed matter. Matter may be listed on 17th on this month. Item number 10 from the petitioner, sir, I'm mentioning.
Why?
Because my senior, Tara sir, is not difficult to come today.
Wait.
It's on 17th, Tuesday.
Just give me 5 minutes. Okay, that proceeding land matter.
Yes, it was.
Okay. नहीं चाहिए मैंने समझ नहीं चाहिए. Okay. On the prayer of the Learned Counsel for the on a prayer made on behalf of Mr. T.T. Tara, Learned Counsel for the petitioner, and not objected to by the Learned Counsel for the respondents, raised me to list these matters again after 4 weeks on a date to be fixed by it.
No, sir, that interim order is there. That may be continued.
Interim order?
Yes, sir.
List this matter again on Tuesday. Huh? Interim order passed earlier to continue till the next date of listing.
Deeply worries.
Yes.
May I allow to mention for a listing of 16 of 2020.
Lordship, I beg to mention item number 26 and 27. I, on behalf of my senior counsel, Mr. A. Saring, who is the leading counsel of this case, since the leading counsel is out of station and he has instructed me to withdraw this case, as the petitioner don't want to continue the case. So,
Are you in the case?
No, I'm not in the case.
So whoever is in the case, ask them to come. We will withdraw it or we'll dismiss it for that's the last order.
So, Lordship, kindly the case may be leased tomorrow.
No, today. Tomorrow I'm not coming. But tomorrow is Friday. Or Friday I'm coming.
Okay. Please kindly list the matter tomorrow.
No, today itself. You get somebody who is there in the case, or I'll. Anyway, you want the case, you're not interested, I'll close the case for dismiss for report. That's all.
Yeah. Would like to know.
All one. 26, 27, let it be there. All when it comes. One. Mr. Sering, I passed the order. We have asked the deputy, the district judge to make the assessment strictly in terms of subsection 2 of section 94. Take into account your birth certificate. We have even indicated in the order that in the original birth certificate, the name was wrong. The mother projected that she has got it corrected. So both the certificates, originals would be produced. I'm not allowing, I have just given 45 days time for that. Thereafter 2 weeks, he will place the report before the registry of this court. Your interim application for suspension will be considered after the report is received.
Otherwise, it would be.
You are not the person who has got to establish that because you have got no role in your birth certificate. Your birth certificate is by your parents. Let them come in.
Yes, if my lord, if I'm being determined, after determination, if I'm being considered as a juvenile.
You immediately, then the whole proceeding will go.
That is the
sentence will go.
For the interest of justice,
so we are not convinced because the manner in which the certificates have been taken, some doubt remains.
Since I have submitted the original certificate.
Yeah, I know that. You have seen it. But we have had experiences to that with regard to issuance of birth certificates in Assam. You are there.
Only consideration was, my lord, since if at all, after the determination,
Mr. Sering, we accepted your first prayer. I'm sorry. The second prayer is deferred. Not rejected, deferred. Let's say you appear. I've made provision that you appear, file an application, he'll fix a date. On that day, the accused will also be produced. And I have also directed that the original records be examined of the birth certificates.
Yes. Right. Online.
Item number 1, disposed of 2 रहेगा, no? 2 and 95 रहेगा, 1 IA disposed of. Oh no, not disposed of. Not disposed of. Pending. All are pending. I've given a date. He'll give it to you. Yes.
Your Lordship,
Hmm.
Your Lordship, before coming to the merits of this case,
Hmm.
I'd like to take Your Lordship to the first order of this case. First order.
Those are interim orders.
So,
Those are interim orders, Mr. Counsel.
yes, yes.
So now the final order is to be passed. Convince me that I'll have to remain with the interim order. I'll pass the interim order.
No.
Same.
So what I mean to say, Your Lordship, is that the state took so many times to file the reply. And the reply is very essential because the act itself says, the APP Act itself says,
Mr. Tapin is here. He'll make his submissions. Yes, Mr. Tapin, what is your stand on this? Is university also covered with the under that?
No. Here Lordship, as per this new act Lordship, Honorable for this public examinations, this act of 24 Lordship.
It is also an authority.
Is a
Authority.
No.
So it will not be covered by
no.
that act is not applicable in my case.
why?
Because that act came after the,
Mr. Counsel, you show me any body and tell it is an autonomous body, I'll accept it. But university cannot be under the government. It's a clear cut. It has got a different sphere of existence. We cannot bring it within the purview and say the act itself says that it will make the appointment.
Yes, Your Lordship, my submission is that the appointment is not the issue here, Your Lordship.
Have you appeared?
Yes, I have appeared with the permission of this court.
But you have appeared?
Yes.
We'll direct them to declare the results. Whoever is selected will be appointed. We will keep the matter pending. This is a big issue. We'll have to decide it finally.
In that case, Your Lordship, they may be allowed to declare the result, but the final appointment may not be done.
No.
Because in that case,
No.
Your Lordship, the matter-
One man, we can't put the whole system into thing.
yes,
Subject to outcome of the case.
that will bring more complication, Your Lordship.
More complication.
Yeah.
Then I'm disposing it off. Then there is no complication. Okay, make your submissions.
Then I'll,
Yes. First submission.
now then, I would like to, the APP SSB Act, Your Lordship.
Where is it?
That day I gave one copy to Your Lordship that day, but
That day you give me?
yes.
Okay.
But even I have one more extra copy.
No.
Here I have less one.
No, wait. Yes, I have it. Arunachal Pradesh staff selection, because this act, because I made my markings there.
Yes.
Yes, come.
The section 6.4.
Act of 2018. 6 point?
4.
Okay. Section 6.4. Oh, okay.
Yes. Now this says, notwithstanding anything contained in any other law for the time being in force, or rules, regulations, bylaws framed thereafter, relating to the appointment to the services post in and conditions of services of employees of the government departments, organizations, and autonomous bodies established, constituted by the government and semi-government organizations. This particular. The board shall be the authority competent to conduct examinations for appointment to the subordinate services, post officer government departments, organizations,
Hmm.
and it shall be the duty of the board to conduct such examination.
Done.
Yes.
Hmm.
Now this clearly says any autonomous bodies which is constituted by the state, it will cover that.
Is the autonomous bodies constituted by the state by way of an act of the legislature?
That is one issue. But nevertheless, the ultimate fact remains that it has been constituted under the state of
Mere constitution will not do, Mr. Counsel. They are governed by UGC regulations, UGC acts. It has a different connotation altogether.
This is not a central university.
They treat it as it makes a state. Any university is covered by UGC.
Yes.
Huh.
But now the what is
Now, what is your big problem? What is your locus here? This is not PIL.
it is not PI.
The examination is held by the university or by the staff commission. What difference does it make to you as a candidate?
Yes. Because I'm alleging malafide.
Malafide against who?
Yes, against the university.
Why?
Because as of today, there are 25 persons working without being appointed. Although it is not in this case, but as of today.
As
So,
of today,
yes.
25 persons are working without. How
Yes.
does it have a bearing on this case?
Yes, because now since such persons are working without any advertisement or without any appointment,
Hmm.
it is very likely that such practice may be adopted in this fact also. Now, had there been
Where is your pleading to that? Where is your pleading to that?
this point, I have to defend it in the
Then please don't argue.
Yes, yes.
Next point.
Now,
We have enough points to go into, which is not there, don't take us. Next point.
yes. Now, even the heading of the APSSB, Your Lordship,
Hmm.
it also said that the same thing. The very
That
motive
is your first point.
Yes.
We have got it.
Yes.
We accept that. Next.
Then if we look at the this University Act, Andhra Pradesh University Act,
Hmm.
there is not a single whisper
Hmm.
about the about what it is reflected that they shall be the conducting authority. Of course, there are provisions which says about that they will be the appointing authority, but there is not a
What
single-
does that appointing authority
Yes.
mean?
Yes, well, appointing and being exam conducted, these are two different things. Like you see, all the bodies, they have their own recruitment rules.
Hmm.
Exactly in the case of Arunachal Pradesh Public Service Examination.
Hmm.
Now, what happens? The other departments, they have their own examination, RR, but nobody conducts the examination. It is only the Public Service Commission who
Now
conducts
see the
examination.
wording at page 17 of the IA. To
Of the-
create administrative, ministerial and other posts.
Yes,
So while creating, they lay down the norms. And while laying down the norms, that norms are normally laid down by the statutes.
yes, sir. Yes, sir.
Ah.
I am saying that they will create, they will appoint, but they
Ah.
cannot conduct. That is
That cannot be taken away.
Hmm.
Third point. Fourth point. Next.
Now, the fourth point,
Hmm.
if we look at again, the same act of the APU, page 4, you see, page 4 of the Andhra Pradesh State University.
I'm looking at the State University Act. only.
Yes, yes.
Hmm.
The section 27, you see.
Hmm. Yes.
27, it says,
Hmm.
to receive with the approval of the state government, benefits, donations, gifts and grants, and to acquire, hold, manage and dispose of the property, movals or immovable
20
27, section 27.
of the University of the
It is,
Act.
yes, yes, it is 5, section 5.27. Section 5, powers of the,
Section 5,
yes, and point
527.
Yes.
Okay. Twenty
27, you see.
page
4.
page 4. 1, 2, 3. Oh, you have not given the middle parts. Council, the Act middle parts you have not given.
My lord.
Pages 527. Okay.
13%.
To receive with approval so and so, donation so and so, so and so.
Yes.
Not very.
So, yes, what I'm trying to say by this point is that even for receiving donations, they have to take the approval of the state, which implies it is totally under the,
Any governmental organization receiving donations
yes,
from certain bodies will have to take a.
acquiring land, hold and manage. So this point implies that it is the government who is monitoring the whole.
Don't stretch 27 to that extent. You come to section 20. Eight,
Section, you see.
section 28.
Yes, yes.
So the power has been given to them to govern themselves. Right? Okay. Anything more?
Yes.
Anything more, Council?
Yes, yes.
Hmm.
Now, again, if we look at the section 7 of the APP SSB Act, Your Lordship, section 7.
Please make your submissions. Continue, make your.
Now, this section 7 says,
Hmm.
whenever there's any contradiction between different organizations about who will conduct the examination, The con-
shall refer the matter to the Department of Administrative Reforms,
Yes.
Council, so and so. So we have Tapin here. We have Tapin here, we'll ask him. We have Tapin here.
So,
Anything more?
so my final submission, Your Lordship, is that now the act is clearly itself says that it shall cover the autonomous body.
Your act, if your submission says one,
One more, Your Lordship.
the act of 2018 will have an overriding effect
Yes, yes,
for all.
yes.
Even the ministerial staff of the university has to be appointed from the candidates recommended by the board.
Yes.
This is your underlying
Yes,
point.
yes.
Done. Yes. What do you have to say?
My lord, the rector of the autonomous body of this university is like the person promotes vice chancellor has been first vice chancellor has been appointed by the vice chancellor. Thereafter, first finance officer and registrar has been appointed by the chancellor. Thereafter, vice chancellor will pass an ordinance addressed to the chancellor for any kind of things. Thereafter, vice chancellor will form a committee, that is the executive council. Executive council is the head, that is chaired by the vice chancellor.
His
And-
submission is that it is also an autonomous body, and if it is an autonomous body, it will be covered by the 2018 Act. What do you have to say on that?
No, 2012 itself says that this autonomous body. The character of the act itself speaks that this university is autonomous body.
So it's an autonomous body created
Yes,
by the state
yes,
government.
yes.
So it will be covered by 2018.
No,
Then-
my lord, this university is funded by not only the state government. This is funded by the Ministry of Education
It-
and other
funding is
governing
not
bodies.
coming in, mister. Funding is not coming in.
Mm,
It is the creation.
mm.
It is created as a autonomous body by the state. So he submits that if that be so, then the 2018 Act would be applicable.
No, 2000. There is three kind of act has been inserted. One is the Arunachal Pradesh University. Another is
2018.
yes.
And then the
18
third act, which Mr.
2024,
Tapin, unfair, 2024.
24. 24 also speaks that university autonomous body. can-
Naturally, we'll have to have.
And accordingly, my lord, the university has framed a recruitment.
Hit
rule.
the point directly.
Yes, ma'am.
Why are you going circuitous? Come to the point directly. 2024 Act is for recruitment.
Recruitment.
And the body, university has been prescribed as a recruiting body.
Yes.
End of the matter.
Yes.
Sit down. Mr. Tapin, what do you have to say?
Affidavit is almost ready.
Hmm.
What is says also, if also see the 2018 Act.
Hmm.
the basis of the
Hmm,
Act also.
hmm.
And
Hmm.
it also come to
Hmm. Hmm.
Section 2O,
Hmm.
2O,
Hmm. 2O.
2O,
Hmm.
subordinate services of the post.
Hmm. Means all groups in government departments, organization. So we'll have to read the autonomous bodies in relation to the earlier two terms, departments and organizations. Autonomous bodies falling under those departments and controlled by the departments, this act will be applicable.
So here what it says also, as per the draft process,
Hmm.
may be notified by the government to be subordinate service of the post. In respect of this staff of the Arunachal Pradesh University also,
Hmm.
such notification has not been issued by.
With regard to the others, there is a notification.
It's same also.
Means all group C posts in government departments, organizations, autonomous bodies established, constituted so and so, and includes such other, no, this is different. Okay. You mean to say that there is no notification bringing in the university staff or the university posts within the purview of 2O.
2O.
But his case is when you have already said autonomous bodies established, constituted by the government, it automatically comes in.
So since law says AR department has not been implemented law,
Hmm.
so there was proper and instruction has not been received. Otherwise, this 2O also. these laws, autonomous body laws and all. It's same process, this also comes under this law.
Okay.
Because this is act law.
So this will require, according to you, a deeper examination.
Deeper examination.
Okay, fine. Okay, fine. We'll not finish off the matter. We'll only consider the I. Okay, we'll vacate the order.
Since he has participated lawsuit, then the
No. IA we will vacate and we will keep the WPC for a detailed hearing.
and act of 2024. Why I'm not pressing that law? Because that comes after lawsuit and
Okay.
enforcement explanation.
But we can take a clue from that.
Yes, that is there. Sources have been already.
Otherwise, why is the university also being included there? It did not have been. Done.
Yes, my,
Patient only in coma, still alive.
my,
Chimba. I disposed of.
Your Worship, my objection to the IA may be kindly,
Everything will be taken note of,
let it.
including the fact that you have appeared in the selection in pursuance to directions passed by us. Done.
Here, department may be implemented.
That's for the final hearing. If they want, they'll do it. That's
Your
not
Worship,
for it.
I think I agree with the submission made by the Learned Council for the State.
Okay, after the dismissal of after the vacation of the IA, you bring in AR, no problem. You are at liberty, but we'll not pass any order. You file an application. There is a caveat.
Yes,
The first two extensions were bilaterally done by you.
only one extension,
Only one extension.
6
bilateral.
months,
6 months.
mutual come.
Mutually. Yes.
Well,
What is
our-
the mistake?
Well, our contention is,
Hey, Arbitration Act 1996.
our contention is, Malad, only limited to that extent, Malad, the finance court
That
below
this
had
will have to be done by the High Court,
High
not
Court
by the.
original jurisdiction is the only high court.
Establish that.
Yes, Malad.
Establish that. Establish that.
Yes. Malad, Malad, so
And
far,
mind you, one word, one caution.
Malad,
The Guwahati High Court does not have an original civil jurisdiction. And unfortunately, I forgot. There are two decisions of the Supreme Court, one from West Bengal, another from Jharkhand, full constitution bench, where that provision of 29, na?
yes,
29, 4, A4 was interpreted, and it was held that, see, the court would be the principal court or the high court. You have those judgments.
Madam.
This is the latest judgment where decision of the Meghalaya High Court was SL. And there your lordship may see,
This is the thing. It is
the
the
law,
principal civil jurisdiction which include provided High Court has original civil jurisdiction. Finish.
and then
If the court finds that cause of delay is one or all of the arbitrator, no, this second part has not come here. It's only with regard to
no,
the.
their principal
jurisdiction.
contention before the learned district court was that in terms of
29-4.
2946 is that the district judge may not be having the power to remove an arbitrator. Now that the Honorable Supreme Court has very clearly said that that is a consequential thing and that will not alter the jurisdiction of the court.
See, those issues are
Are
there.
not there anyway here.
Those issues here, we are only concerned
Yes.
with the preliminary issue that has been decided. Whether the court had the power, your objection that it does not have the power,
Correct.
it has said, no, we have the power.
we have the
And-
power
and
by virtue of
rightly-
the, Malad, the original.
And
civil-
rightly so. And rightly so. Because it says 29-4, the court, definition of court is in
2-1.
2-1 Arbitration Act 1996. 2
through 1E.
2-1. been out of touch for long with this.
Your Lordship, there's even a Guwahati High Court decision
Uh,
clearly on this issue. But that
our
has our High Court.
Okay.
We need not travel to any other High Court, but our own High Court has decided this issue.
By
Honorable Justice Ujjwal Bhuyan.
but what was the name of that case?
A plus project and technology.
But there it was a case wherein the parties had, I think, appointed the
With the
arbitrator.
arbitrator.
Here it is by 11-6.
But there also the Honorable says,
I don't know. Two, you were.
2-1E.
2-1E. Court means, in case
In-
of arbitration other than so and so, the principal civil court of original jurisdiction and includes High Court in exercise of its ordinary original civil jurisdiction. Clear. So, give it a closure.
My lord. That is the only my lord contention on the law
Also,
point.
heard Mr. M. Kato, learned counsel for, KVL.
Okay. There is a caveat.
KVL discuss करके दे रहा हूँ. Only one, Mr. Sanavati, only one.
One respondent.
Only so. But Mr. Kato, learning counsel for the appellant, of the petitioner, and Mr. D. Senapati, learned counsel appearing along with Mr. B. Pincha, learned for the sole respondent. The challenge in the present proceeding is to an order dated 39/2024 passed by the learned district and session judge. ये पूरा लिख लेना. Districts of West coming, Pakke Kesan East coming, order का ऊपर में हाँ. In arbitration
Number 01. That's how it has been numbered.
Arbitration number 1/2024. Thereby deciding the issue of preliminary objection raised by the petitioners herein with regard to the jurisdiction of the court to entertain an application under section 29A, bracketed 4, bracketed. Was an application under 29(4).
Yes.
29(4), 4 only.
For only man.
4. Application under so and so for extension of time for what is it called? Delivery of delivery
Extension of the mandate of the arbitrator.
for extension of the mandate of the arbitrator to pass the award
Award.
in the arbitration proceeding. So
Ongoing.
so involved in the matter. So Mr. Kato has submitted that the arbitrator in the arbitrator in the matter was appointed by this court, and accordingly it is only this court which would have jurisdiction to entertain any matter so arising during the pendency of the reference involved, and no other court would have the jurisdiction to entertain the matter, and accordingly submits that the learned district judge had erred in arriving at a conclusion that it had jurisdiction to entertain the application so filed before it by the respondent herein. So, Mr. Dev Sanapati, learned counsel for the petitioner, after referring to the provisions of section 29A4 as well as to the provisions of section 2(1)E, wherein the definition of court has been defined and has submitted that such court would be the court of the
Original.
the principal civil court of original jurisdiction in a district, and also includes the High Court in exercise of its original civil jurisdiction. It is submitted by Mr. Senapati that this court does not have an original civil jurisdiction, and accordingly it is the principal civil court of the district which would be the appropriate forum, and accordingly the respondents had approached the appropriate forum by way of filing the application under section 29 bracketed A, 29A bracketed 4 of the Act of 1996. In support of his submissions, Mr. Senapati has raised reliance on a recent decision of the Honorable Supreme Court in the case of Chief Engineer bracketed NHPWD bracket roads versus BSC and C and Roman and C and C. हाँ इसमें से देख लेना. Special leave to appeal bracket में judge order dated 13/5/2024 in SLP bracketed C numbers 10544/2020 and has submitted that the present in the above premises, Mr. Senapati has submitted that the present revision petition would be called to be would be required to be dismissed in limine. Learned counsel for the parties and also peruse the materials available on record. The application under section 29A bracketed 4 having been instituted before the learned district judge who so and so by the respondent hearing, a preliminary objection came to be raised in the matter by the petitioners, and therein it, as noticed herein above, it was contended that it is only this court, in view of the fact that it had appointed the arbitrator in the matter, would have jurisdiction to pass any orders to entertain any application so filed in the matter during the pendency of the reference before the arbitrator. Full stop. It is noted that the provisions of 29A4 refer to (29A bracketed 4) refers to the word court. Word court is defined under the provisions of section 2 bracketed 1 bracketed E of the Act of 1996, and the same being relevant is extracted herein below. So a perusal of the provisions 2(1) E bracketed 1. So the present not being an international commercial arbitration, the court would mean the principal civil court of original jurisdiction in a district, and also would include the High Court in exercise of its ordinary original civil jurisdiction. It is to be noted that the Guwahati High Court does not have original civil jurisdiction. So in this connection, it is required to refer to the decision of the Honorable Supreme Court in the case of Messrs. BSC and C and C JV. The conclusions so drawn by the learned Supreme Court in the matter being relevant is extracted here in below. Isko order ko extract kar do. A2. In view of the said conclusion so drawn by the Honorable Supreme Court of India in the above noted decision, and the same squarely applying to the present case, this court is of the considered view that the decision of the learned district and session judge is of the considered view that the order dated 30/9/2024 passed by the learned district and session judge in arbitration number 1/2024, holding that it had the jurisdiction to consider the application so filed by the respondents herein under invoking the provisions of section 29A bracketed 4 is not erroneous and would not require any interference. In view of the above, the present civil revision petition stands dismissed. However, there would be no order as to cause. What is that decision of the Guwahati High Court?
A plus project and technology.
The citation.
Citation is just one, Your Lordship.
It will come into handy somewhere. I forgot.
No. I don't know the 2020 1 GLR 1999.
SCC, it is there.
SCC I have not looked up.
A plus, no?
A plus project and technology.
My Lord Justice Mia's.
My lord, in another, my lord, the recent judgment of the Honorable Supreme Court, it has observed that, my lord, it is the subject matter of the interpretations is to, my lord, postulated in the section 29A 4, my lord, and 4 and 6, my lord. That was the, my lord, the recent judgment.
I have only upheld the
Yes.
decision with regard to jurisdiction. I have not
Jurisdiction.
gone into the other aspects.
So therefore, my lord, the jurisdiction, my lord, as we have already contended that the commercial code, even if it has to be, my lord, the commercial code has to, my lord, the designated, my lord. That is the one aspect.
That you
That state government will.
No, my
take
lord,
it
the
up.
subject matter of the interpretation is
29(4)(A)(4), I think it's clear.
Clear.
But Delhi, Bombay,
Bombay,
Madras, Calcutta.
Meghalaya also.
even in, my lord,
No.
Guwahati also,
Meghalaya
my
does
lord.
not have original jurisdiction.
Original jurisdiction.
These
Only
4
four.
courts, it will be the High Court.
It will be high.
Not subject to their valuation.
Valuation.
He needs to dismiss.
They play.
Okay.
May I proceed?
Hmm.
Your Lordship, this is a joint petition filed under section 528 of BNS for quashing and
Madam,
yes, yes, sir.
you want to press this application? I'm not convinced. This is heinous. This cannot be condoned. At least I'm not quashing it. Yes, madam.
Yes, Your Lordship.
Want to take an adjournment, take an adjournment. Otherwise, if I have to come in, I'll dismiss this. I'll hold it as abuse of the court. And what is the ground
On
of
mutual-
settlement? Nothing.
Yes.
Just 2 lines you write, it is settled, it's settled. Make out a story. How can you? This is a clear crime. This is crime against society. We cannot. Not dismissing it, young girl. You right. When is the next date in the law court?
In the month of, I think January or February.
February. List this matter again after 4 weeks on a date to be fixed by the registry. Right. But if it comes to me next time, I'm dismissing it. Highest quashing is being done, I think, by me when I sit here. But these matters, no.
Yeah, please, Lordship.
This is that husband and wife together.
Lordship. Lordship here, Lordship petition number
How
1.
can the husband
Lordship.
enter into a compromise?
Lordship,
He is not the sufferer. The sufferer is the wife.
Lordship.
Is the wife a property of a husband?
Lordship, I am
Then-
complaining, Lordship.
I know that.
I'm the complaining, Lordship.
But if there has to be this injury is suffered by the lady,
Exactly.
not by he just informed about the incident.
Lordship,
He
Lordship,
might have lost some money.
Lordship,
but
matter
the
has been already
lady-
settled amicably, Lordship.
No. We are
Lordship,
not.
and we are having no any, we
No.
are
In the
not
settlement deed
pursue
of
this matter
settlement, the
anymore.
lady is not there.
Yes, exactly.
Lordship.
The
And
lady is not there.
other co-accused signature is also not there.
Then there are other co-accused also. They are also not there.
Lordship, for them, Lordship, Lordship, accused is there, Lordship.
Okay, the lady is not there.
Lordship,
And the
leading accused is there,
injury is
Lordship.
suffered by the lady. As in,
Yes.
can we close our eyes to that? Face trial. We are dismissing this.
Lordship, the matter has been settled, Lordship.
You settle
And
it.
Lordship,
That
we are-
settlement.
Lordship,
Then why are you before? If you have settled it, go and make a statement in the court.
Lordship, we are living our life peacefully.
You do it. But we
But
are
Lordship,
not.
we are
I'm sorry. I'm
Lordship,
sorry. Yes, what do you say?
Yes, punishment is up to life and
Life.
minimum is 10 years. Rigorous with
And
rigorous
lordship,
This
imprisonment.
is abuse of the process. of course.
lordship, is still lordship in trial court, lordship, charge has been not framed, lordship.
Fine, very good.
Lordship.
Rest assured. You rest in peace, no problem. But thing is, we are not interfering with this. Very serious. Acid.
Acid attack, yes.
She was thought to be killed, and you want us to quash the proceedings on settlement? No, and that too when the lady is not there. You withdraw it, else I'll pass adverse things, which may affect you in your trial also.
Lordship, I will withdraw, lordship. And lordship, liberty may be given.
No liberty. Face trial or go up on appeal. No problem. Your name?
Ketabang, lordship.
Ketama, learned counsel for the petition, and Ms. Taru, learned additional public prosecutor. After attempting to argue the matter at some length, Mr. So-and-so, learned counsel for the petitioners, submit that he be found.
Lordship,
to
kindly,
withdraw-
liberty may be given, lordship.
Withdraw the present petition. Full stop. With liberty. With liberty. Full stop. With liberty to institute fresh proceeding if circumstances so mandate. Full stop. Prayer accepted. Criminal petition stands dismissed with liberty and spirit.
Popular judge.
Heavily arrested.
Mr. Ede, have you got it?
Yes, your lordship. And your lordship, we missed out one this effect in the affidavit, your lordship. The what exactly has happened on that day, your lordship? The three of the inmates, your lordship, actually there was four accused. One was the deceased person, and
They were there.
yes, and three of them, your lordship, three of their remand period was over. So on that day they have taken to the court for production.
What was the time it was around
Yeah, 16,
10:30
yes, so it's there in the
PM.
yes,
At 10:30 PM, who had taken them for that production?
your lordship, is record is there in the record, your lordship. Even in their explanation is there. Your lordship, I will directly take to the affidavit, your lordship. Let us first understand the fact, what exactly
let's
is.
get the facts.
Yes. Your lordship will find in paragraph 5 of our affidavit, your lordship.
Hmm.
Para 5. With regard to the statement made in para 4 of the petition, the deponent begged to state that after his arrest, medical examination was done and was produced before the court on dated 11/8/15, where he was remanded to 6 days police remand for purpose of investigation, and he was kept in PS lockup with other inmate, namely Taikaha and Sahil Ahmad, arrested in connection with Nahalagan PS case number so and so under section so and so in same cell on 13/8/15 at about 14:30 hours on expiry of remand period of arrested alleged accused Taika and Sahil Ahmad, who were forwarded to the court for the further remand with proper escort at about 16:20 hours, while the escort party with remanded alleged accused so and so was returned back to PS, leaving one UTP Taitada at district jail, and where while relodging them in the cell, Constable Tumpa Ruttum, who was deployed as sentry, noticed that remand alleged accused Michael Deka hanged himself inside lockup near lockup door. He immediately informed duty officer SI Suresh, who rushed to the lockup and found so and so committed suicide by hanging by his t-shirt. A case was registered under so and so, and this is the fact, your lordship.
What was the time of the suicide? Mr. Deka, what was the time of the suicide?
4:30, my lord.
4:30.
Your lordship, they reply to this affidavit in their rejoinder, para 4, your lordship.
Rejoinder?
Yes, your lordship, para 4. Page 7, your lordship.
This is affidavit by 3 and 4. 3 and 5.
Yeah, 3 and 5 is the government side, Your Lordship. The response to that about statement, Your Lordship, they have filed.
Para 4,
Yes, Your Lordship.
page 4.
Yes, Your Lordship. Maybe, but in our we got the separate one, Your Lordship.
This, which part is a long paragraph? Which one you want to?
Your Lordship, the first portion only, Your Lordship. With regard to the statement made in para 5 of the affidavit in opposition, the humble deponent states that she does not admit the same and reiterate that the statement made in.
Wait. There is some problem here. Para 5. Para 5, yes. Oh, there are two paragraphs. Okay, fine. Para, page 7, yes.
Yes, with regard to the statement made in para 5 on affidavit in opposition, the humble deponent states that she does not admit the same and reiterate this statement made in para 4 of the writ petition. The deponent further stated that even assuming that the alleged accused might have committed suicide inside the police lockup, where there were other 3 accused persons, namely so and so, from whom a huge catchment of NDPS substance were recovered, it cannot be presumed that the alleged accused Michael Deca committed suicide in presence of other co-accused. Here, Your Lordship, they are saying the other inmates were present.
Okay, got it. Where is your that?
Yes, record, Your Lordship.
Where is their replies?
Your Lordship, I marked their
Okay,
reply. Your
okay,
Lordship.
okay. Mr. Deca,
My Lord.
if we find that they things meet, and there was actually, your only thing is the presence of those three people in the jail,
Yes,
police station jail,
police custody.
police
matter,
custody
lockup.
jail, lock up. Then how could he commit suicide? That's the
Yes,
only
yes,
thing.
yeah, yeah.
Mr. Ete now has tried to distinguish that those three had been taken for their production.
Yes, ma'am.
So at that point of time, you were alone in the cell. We'll go through this.
Yes, ma'am.
Anything more you want to add?
My lord, here, the cause of suicide is with by a sporting. That is also suspected.
That how can this is?
Yes.
That's a very unfortunate thing, but can't help it.
Yes. My lord.
Now, for imposing a compensation, I'll have to have some material.
My lord.
Merely death in the, will a mere death in the suicide like this, will it not also amount to a negligence on your part?
Yes, yes.
For that, would it not be entitled to
It is
something?
broad daylight, my lord.
But your lordship, not on the record, I don't have any instruction, but your lordship, I have gone through one judgment, your lordship, where it says, your lordship, if the right of an individual, which is granted under Article 21, is curtailed in accordance with law, at the same time, the person who has the custody also have the responsibility to protect that right. So in that aspect, your lordship can
Something should be.
yes, your lordship. That is there, but your lordship, it's my
No.
well understanding.
So, see, this is not adversary. We are trying to, if that lady is something, what would be the minimum?
That quantum, your lordship.
We'll fix a quantum. And, okay. Can you give me that judgment?
Yes, your lordship.
My lord, I also would like to rely on judgment. That is 2017 10 SCC 658.
Your lordship, this judgment is Nilbati Behra Srimati alias Lalita Behra through the Supreme Court Legal and Committee versus State of Orissa. Here, your lordship, the right to life.
Was.
Yes, your
It's
lordship. But here, your lordship, there was some negligence from the part of the police authority. But so far as your lordship, the right to life is concerned,
My lord, here paragraph 46 and 48, my lord.
इसका एक प्रिंट आउट दे 2017 10 SSC 658. 2017 10 SSC 658. Just give me a print out. Only please. And that it is.
this is a
judgment
copy
also.
of the judgment, your lordship.
You can keep the copy. She'll take out a copy for me.
Yes, your lordship. I have the copy, your lordship.
No. It's okay.
Because your lordship, I try to find out, just like MSCT, no fault liability is there in this kind of offense, but no such judgment is
No
there.
fault
Your lordship.
liability is not there.
Yes, your lordship. But so far as
But in this line, there are few judgments.
yes, your lordship. Liberty, right to life and personal liberty, if it's curtailed, at the same time, the person having the custody have the same duty and responsibility to protect it.
My lord, I happen to got lost my healthy and sound son due to negligence of the police and because he was only 24 years young man. So losing him, I am suffering from
See,
irreparable
his
loss.
lodging is not, cannot be held to be bad because
Why?
the offense he was lodged for.
Yes, my lord.
And, but the thing is, after lodging him, they also ought to have been careful.
Yes.
Just taking a plea that you have committed suicide, so nothing is committed, will not be. We'll consider. But the parties at length, raised it to raise this matter again on 17/12/2024 for delivery of orders.
Okay, your lordship.
इसको हमको चेंबर में दे दीजिएगा.
Deeply obliged, your lordship.
Delivery of orders. Yes, Mr. Das,
May please, your lordship.
what brings you here?
Sir, it's a small issue. Could
May I
it-
please, your lordship, conducting counsel, she is engaged in court number 1, your lordship. May kindly be passed over.
No, get her, no problem. We
Start, my lord.
let him start. Very narrow compass,
Yes, basically,
unsound mind,
yes,
page 70.
yes. There was an incident of intermittent firing.
But
there is
what
no
of
iota-
that we did not go into.
Yes, that we need not go into.
Now your case is that for the extraordinary leave period,
Yes,
have they not regularized that period for even for pension notionally?
what they said that will be counted for. I'll just take your lordship to the.
Page 70,
Yes, page 70.
it will be counted for pensionary benefits.
Pensionary benefit.
So
but-
if it counts for pensionary benefit, that period has to be regularized. If that
Yes.
period is regularized, notionally, you get all those
increments and
increments
benefits,
and the benefits.
ACP
That
and
much only you want.
that much only, nothing more than that, my lord. And for that purpose, my lord, I have annexed one OM also.
Hmm.
In the additional affidavit, your lordship will find. Because I,
The additional affidavits, is many files.
actually, I annexed in the repetition, but it skipped, so that's why I brought on record. that-
This is the document you have taken to leave for.
Yes,
Which is the portion you want to?
page 4, your lordship will kindly take up.
Hmm. Hmm.
Under the amended rules, both in case of temporary and officiating and permanent government service, extraordinary leave taken on account of illness and
No,
government
this will not be there. This is different.
It says extra, because
Extraordinary leave, when it is on medical grounds, then it is automatically coming, and that is
It's-
there in the CCS,
Yes.
CCS leave rules also.
yes, it says
46, I suppose.
taken on account of illness and covered by proper medical
No,
certificate.
no, this is not the EOL which you are.
What they have, what, by referring to this, what I'm trying to substantiate before the lordships is that there were medical certificates, the disciplinary authority could have considered those medical certificates and come to a conclusion with regard to the increments and all.
See, it's not the medical, it's not a medical certificate, it's not a question of absence. It's a question of
Yes.
suspension and
Yes, 54.
P. It's an order passed under 54P. So once that is there, how will you have said two things. That last two was for pensionary benefits. Now, this to be beneficial for pensioner, it has to be treated as qualifying service.
Yes,
So this period has to be regularized by way of increments and all over those benefits, but you will not get anything.
salary, I am not saying that I'll get.
When
the
did you
salary.
finally retire from service?
I retired from service on 22/8, sorry, 38/2022. They have made the calculation of pension basing on the last pay drawn, and his pay has been fixed as like a newly recruit at the after the.
That you have said.
Yes, my lord. Under
So
the
only
salary.
thing we can ask them to do is to fix your case pay notionally
Yes,
till the date of your retirement, your reinstatement,
yes,
and thereafter to do what is required to be done.
yes, my lord.
For that period, what is that period? Suspension and
He was,
suspension and dismissal?
yes, he was suspended by the order dated 15/11/1993,
Suspended 15?
11/1993, and dismissed by the order dated 10/5/1994. And dismissal under 311(2)(b, no inquiry, nothing.
Be that as it may.
Yes.
Then
Then
reinstatement,
reinstated,
appellate authority,
appeal, the orders
Reinstated.
11/11/2019. Appellate authorities order,
11/2019.
page 68. And joining report 18/11/2019. Page 71.
18/11/2019. We will not specify as to what you will get. We will only say that the period having been now held to be also counted for pensionary benefits.
Yes,
So this period of your absence from 15/11/93
yes,
till 10, 11, till 17, 2019.
Yes. This period has to be counted for the purpose of increment and other service benefits also.
So they will notionally fix the increments and notionally fix the increments, also the pay revisions that come into being.
Yes, revision.
And on 18/11/2019 onwards, you will be entitled to the revised pay, which
Yes.
you will not get. But this notional will go on till your retirement, and from the pensionary benefits, this will be given. But you are not
Exactly.
getting anything till you were in service.
Salary, I am not saying, because although if I rely FR 54(2), if your lordships kindly considers it, I am entitled for full pay and allowances for that period. The reason is that they did not impose any penalty. By the appellate
But
order,
that order is not under challenge.
which
That
order?
has gone, that 2019 order.
It is under challenge.
Here,
Yes,
In the process-
11/11/2019 order is under challenge. Prayer number 1. So, if we apply FR 54(2),
we will not
you
go into
having
that.
not,
Work.
imposing,
Oh,
no,
fine,
no
fine.
work, no pay principle, I can appreciate. But if we go by FR 54(2),
See, this is a technical order. It's not an order on merits. 11/11/2019 benefits that have been given you, it's on a technicality. Section 84 of the insanity.
technically,
Plea of insanity.
ultimately the court held that there was no
You work
intention
till,
on my part.
thereafter you work without any problem till 22.
Yes, there were some direction that I'll be given a lighter
Lighter.
term and all those things. I continued with that,
Okay.
no problem. with
Till
that.
subject to what they say, yes, madam.
Kindly pass over the notice.
Time being, okay, we have heard him.
So I'll be entitled, I'll be praying for this increments. That
You will get everything for that period, subject to what they say, but no areas till the date of,
only one prayer, my lord, if
Hmm.
possible, FR 52,
we
54,
will not go into that.
applying FR 54(2),
We will not apply.
I'm not saying the full pay and allowances, because
You will not get, you will only get a notional thing.
some back wages. my
I
lord.
can do one thing for you.
Yes, my lord.
I can, the suspension amount, essay,
Yes.
from the date of dismissal, you will be treated to be under suspension. If you want, I can consider passing that order, but no pay.
From the date of suspension till,
No, from the date of dismissal
yes,
till the date of reinstatement, we will direct them to treat that period as suspension.
they have,
And then they release to you subsistence allowance for that period.
they have already regularized the period of suspension. They
No,
Because
they
the
have
moment they-
regularized it that as
70.
UL.
You will.
How
Yes.
can they do that?
They cannot do it, Miller. So once that thing goes,
I
I'm
can
enti-
understand with regard to dismissal onwards.
yes. Miller,
Okay,
Had-
we'll find out something.
had there been some, had they would not have.
But you're not getting salary from 1993 till 2019. After that, we will ask them, whatever the revision comes about to pay,
Pay
also
revision,
revise
Yes.
your,
Fine, Miller. Absolutely fine.
not
Salary,
that-
I can appreciate, Miller.
for this period, you're not getting anything.
Although
Public
I-
money will not give you.
Although this disease suffers, I suffered this disease during the course of my employment.
Be
but
that as
yes,
it may.
it's true, Miller.
But
I
taking
did
a
not work.
totality of the view,
Yes, Miller.
we hold, because they were very magnanimous in their order. We'll only direct that this period from 15/11/93 till 18/11/2019, they will now work out notionally, give you increments, all the revisions of pay that came in between,
Yes, Miller.
and whatever your salary
Yes.
works out as on 18/11/2019, that you will be entitled from till 17/11/2019, that you will be entitled from 18/11/2019. Consequently, your pension and pensionary benefits will also be,
That will,
I think, substantially you get.
yes, yes, my lord. That will do.
And we will write a line that Mr. Das has acceded to that.
Much obliged. My lord, if required, my lord, I have 3 judgments for your lordship's assistance. My lord may have. It may give some assistance to your lordships. I am also not very sure. One is slightly on a different footing, but the whole idea is same, that the benefit is to be given.
I'm also not denying you.
Yes, my lord. In that way it goes, it covers. Basically, Pradip Chandra maybe, my lord, once reinstated.
There is no set formula for this.
Yes.
It's a discretion of the court.
Exactly, that's true.
We are not denying you. We
It's-
are, because of that order,
Yes,
we are giving you
fine,
everything, but you will get it from 18/11/2019 onwards.
fine,
Pension will also do,
yes.
and we will write that you, both the parties have agreed to this, subject to the
Yes.
learned council appearing.
This will give some succor to the.
Done,
person
much more,
concerned.
much.
Yes, yes, much succor, yes.
When Mr. Tapin is coming. Jayate. Okay. He's on legs. Oh, she. Do one thing. You can leave. You can leave. We'll take it up tomorrow. If she is busy today, we'll have it tomorrow. You have heard what has been transferred. Just ask her. You can just
I'll
come.
join a remote VC.
Or
Yes,
remote
please.
VC.
Yes, sir.
Tomorrow.
Fine, madam.
As prayed for by the learned council for the parties. Or Monday. Monday. Monday.
Just.
Busy lawyers will have to have.
It's not like that. Now, just last week before the week.
Okay.
Yes, my lord.
Money bags are waiting.
No, not at all.
Second half.
16.
You'll be.
Monday, no problem.
Monday. Or tomorrow. Tomorrow. No problem.
Tomorrow is also
Come.
fine, madam.
Tomorrow. Heard
Will
the parties.
Permit me.
You obviously.
Yes, yes.
Heard the parties at length. Heard Mr. H.K. Das, learned counsel for the petitioner at length. Ms. G. Ete submits that she be permitted to make her submissions tomorrow. So prayer accepted. Raised it to list this matter again tomorrow as a fixed item. Tomorrow day fixed item. Mr. Das is permitted to make his some further submissions by way of remote, by way of what they call it?
A remote VC.
Remote VC.
RVC.
RVC.
Much of it. Deeply. obliged.
Lordship, this matter may be kindly pass over for timing. Actually, this is going on in this BC. Leading council will be, this will be on BC. So council will be appearing from Guwahati. And now,
Okay, when they, today I think there is some problem, nobody is there. Heard the, on the prayer of Mr. A.K. Pukhaistal and counsel for the petitioner, not objected to by the learned counsel for the respondents, raised it to list this matters again after 4 weeks, not 2 weeks.
no, Lordship, today only it will be,
We can't wait, we have many matters.
matter may be kindly pass over.
No, not today.
Sir, is,
Why this selective doing of cases?
No,
If you
actually,
do, you should do every case.
in court one, the BC, another BC is going.
Please, we requested him, the other matters also, everything we adjourned. So this, because you, because we have to maintain parity. The last week, how many matters were adjourned on your?
Yes, Lordship, but,
So this is on our incident. Yes, next. उनको permission दे, किसी को किसी आने को चला होगी
May I please, Your Lordship? Your Lordship, we have We have received the instruction
Okay.
on regard to the respondent number 8, Your Lordship. We'll be filing it shortly, Your Lordship.
Okay. Say, issue is serious, so don't delay. I'm
Yes, Your
fixing a date. Please file your affidavit on
Yes.
that day. Otherwise, we'll proceed. The forest, reserve forest has been notified. Notified?
Notified.
Final notification has come.
But it was not brought into our knowledge.
How long have you been staying there? You all are reserve community people, SC, ST? Then what, how can they? You
Yes.
have that SC, ST, Protection of SC, ST, Forest Dwellers Act.
Then there are two.
If you can show that you were there for 3 generations,
Yes.
each generation 25 years, what more is required? They get it.
We have got 2 schools and 7 government centers.
No, sir, I'm not on that. If you
Then-
can show, what is that act? Schedule cast, schedule. Okay, let them file their affidavit.
Here, my lord. This notification was issued in 1976.
Hmm.
And we are residing there since 1970 to 2011 census. There is a record. I mean, our village record is there. In 2072.
When was the final notification?
It was in 70.
Draft was in, no. Okay, fine. Madam, your name?
P. Sangeeta, Your Lordship.
P. Sangeeta, sorry. Learned counsel for the respondents. Respondent number 8.
3 to 12, Your Lordship.
Huh?
3 to 12.
Learned counsel for the respondents number 3 to 12 submits that the instructions have been received and she would file her affidavit in the matter on behalf of the said respondents on.
Your Lordship, 2 weeks time maybe.
No, give me a date. You take your time as per your sweet will, but give me that day, this thing should be here.
Your Lordship, in January,
Give me a date, madam. I leave it to you.
31, Your Lordship.
21,
31.
31, okay. On 31/1/2024. Full stop. In the event, full stop. On the next, before the next date of listing, the affidavit should invariably be filed on behalf of the respondents number 3 to.
No, Your Lordship, respondent number 8.
You're not.
Other respondent, they have filed already. Your
Okay,
Lordship.
by
Only
the respondent number 8. So in the event no affidavit is filed, this court would pass appropriate orders as may be called for in the matter. So Mr. M. Patil, assisted by Mr. Tamuma is senior counsel, assisted by so-and-so is present for the petitioners. You are appearing for 3 to 12, but you will be filing it for 8.
8 here.
Appearing for 3 to 12, submits that instructions have been received from respondent number 8. Affidavit would be filed by on or before 31/1/2025. In the event affidavit is not filed by the respondent number 8, further orders, jo hai.
Obliged.
Yes,
My lord.
Mr. Chetri, have you got
My
the
lord,
judgments?
Yes, my lord, I have handed Mr. Deka is there, lordship. Mr. Deka will hand over judgment. Guwahati High Court, I found Jirila Marak, my lord.
Prem Singh gone.
Jirila Marak, Prem Singh.
Dhirenla Marak is also gone. There are recent decisions of the Supreme Court.
One more of Supreme Court, 1 page, I think.
I forgot the names. I thought you will be giving me that, so I did not also vote.
Mahesh Pandey, my lord. Maheshwar Pandey.
Yeah.
No, Maheshwar
There
Pandey.
are decisions which says recent decisions of the Supreme Court that if there is a shortfall, the earlier service should be brought in.
In Sajdeva is also there, my lord. I have given to Mr.
These are gone. These are by the specific to the
Yes, sir.
following Prem Singh. Prem Singh was also followed. Then Prem Singh.
Lordship, there is one more judgment of 1 page, lordship. The state of Gujarat.
This is the one. This is the one. Uday Pratap Singh Thakur. And Uday Pratap Thakur makes a reference to Prem Singh, right? This is the one. This is the one. Yes, what do you say?
I have nothing more to say.
Yes, madam, anybody appearing? We're only saying that the earlier period, any shortfall in the qualifying service, you will take the service, earlier service and regularize. And then they'll send a proposal to the pension department and then that will be done. That much okay. Okay? Thank you.
Highly obliged, my lord.
30. Learned counsel for the party settling.
Lordship, my appearance may be recorded, my lord. My appearance may be recorded last time.
Sure. But Mr. S.K. Chetri,
Sanjay Kumar Chetri.
along Sanjay Kumar Chetri, along with Mr. U. Deka, learned counsel appearing for the petitioners. Also heard Mr. A. Apang, learned senior counsel, assisted by Ms. K. Lawyer, learned counsel appearing for the respondents. One. Also heard Ms. P. Sangita, learned counsel appearing for respondent. T. One more. Learned counsel appearing for respondent. Oh, sorry. Hearing concluded, judgment reserved.
Highly obliged.
You may not get it before vacations. I don't know. If possible, I'll do it, but
All.
after vacations, you will get it.
Highly obliged. Much obliged.
Your Lordship, it's respondent number 2. Respondent number 2 and 3, Your Lordship.
2 and 3. You are for 1 and 4. 1 and 4. Yes. What do you say about this?
Lordship,
The issue.
Lordship, here, Lordship, they have the jurisdiction issue, Lordship.
Mm.
And last occasion, Lordship, the Honorable Court has, Lordship, they have given the interim protection, Lordship. For that reason, the investigation could not be completed.
Mm.
Because the petitioner, he had been to deny it, or they had been not required to appear personally before the police till the reasonable date. That interim was granted. As per, I have received the case diary where the status report is saying that the case is pending for examination of alleged accused, which is the this husband Lordship of the complainant. Lordship, regarding the jurisdiction issue, Lordship, the Rupali Devi Lordship, where it is Lordship, the Honorable Lordship Appellant Court has stated that Lordship, the jurisdiction issue could not be Lordship, Mayor Lordship, because the wife Lordship, 498 the cases, where he's residing, he can also initiate the proceeding Lordship. Yes, Lordship.
So the wife is a resident of.
This Arunachal Pradesh, yes, Divang Valley Lordship.
So if that be so, if Rupali Devi has laid down, then why are we detaining this proceeding now? Let the proceedings go ahead, let the investigation go ahead.
That's why Lordship, it's because Lordship.
Yes.
interim
Counsel,
was
what do you-
already-
Please, my lords. Please, my lords.
Yes.
Please, my lords. I'm appearing in this for the petitioners, my lords.
Mm.
Apart from this jurisdictional issue which my lords have raised, there's a judgment. Indeed, my lords was referring to 2023 Supreme Court judgment, my lords. The lady, she was from Delhi, then she went up to the Rajasthan. There she filed a complaint before the court, my lords. That is something different issue, my lords. Which right now the
Just
respective.
this lady,
Yes.
what is her, how is her roots here?
My lord,
Or is she staying here temporarily?
my lord, initially she was at Jammu and Kashmir with her husband.
No, where was she born? Where was she brought up?
She is from Royang, my lord. Permanently resident of Royang. Her parents is Royang.
Royang?
Royang, my lord.
Assam?
No, my lord.
Arunachal.
Arunachal Pradesh.
Divang Valley.
Divang Valley.
Divang Valley. Okay,
Yes.
fine. Yes, counsel.
Please, my lords. So, my lords, apart from that, in that the Supreme Court said that yes, she can file a complaint. She filed a complaint in Rajasthan court, my lords. But before Rajasthan court, not the FIR, my lord. That's one point. Second point, my lords, is that she is alleging that yes, the domestic violence terror has been unleashed upon her in 2022. Now she is filing a complaint in 2024. The FIR is totally silent, my lord. Indeed, the complainant is herself totally silent regarding the period which she has not approached the police station. Now, lords, what she did,
These are
interestingly,
issues you take up in the trial.
but my lords,
When the police investigation is not complete.
In fact,
The
my
police
lords, but
investigation is not, we have stalled the police investigation here.
indeed, my lords, but my lords, what 482, it gives a vast powers to this honorable court,
We
my
have
lords.
it, but can we use it for each and every case?
No, not at all, my lords.
It is
But
an
where,
abuse of the process of the
yes,
court.
but
An
where,
investigation has been stalled. What is your grounds for stalling the investigation?
yes, but my lords, where there is misuse and abuse of the of the process of the law, my lords, this court definitely has the power to come.
See, we don't know. We know about an FIR which is presently lodged by the respondent.
Yes, my lords.
That is at page.
That's at page 23, my lords. Relevant page 24, my lords.
23.
Yes. Relevant page 24, my lords.
So, if we go per se by this FIR, it
Yes.
is very clear that she is a resident of Rohing and she
She's
has
a-
given this. So,
Yes.
498A can be instituted here.
Yeah, but
And
now,
the
my lords,
other
my-
factors,
yes, my lords,
what happened to those cases?
my lords, may kindly turn the page to 27 now.
Hmm.
This is the
Yes.
domestic violence petition which she has filed before the court in Srinagar, my lords.
DV Act, that's DV Act.
Yes, my lords.
And this is 498A.
Yes, my lords.
Huh.
Indeed, yesterday, my lords, what Honorable Supreme Court said is that there has been grossly misuse and abuse of the process under 498A by the woman.
Sorry, let the government, let the people, let the police investigate. You facilitate the investigation and
But my
thereafter, let's see what, now the whole investigation is stalled.
But my lord, she has already approached before the police station. My lords, we kindly turn to the page 30. She has already
Page?
approached page 30, my lords.
30.
Page 30. 30. Yes, my lords.
Yes, 30.
30. Para number 8.
Hmm.
May I read it, my lords? That the torture of the by the respondent became frequent with the passage of the time. The respondent started physically torturing the applicant number 1 more and more day in and day out. The golden ornaments of the applicant
Okay.
number 1.
She approached the last line. Applicant has also
Yes.
approached the police station, so and so, but without any relief.
Yes, my
So
lord.
she came back to her place and she has instituted this proceeding.
But my
Maybe,
lords,
I'm not denying, not for a moment saying that the only by the investigation in institution of the proceeding, it should be held that the offense has been committed. That is not the law.
right,
But
my
the
lord.
investigation has to go ahead.
But my lords, let it be investigated by any police station in Srinagar where the offense has been committed upon her. I'm not saying
Why
no.
should we ask her? We don't have jurisdiction.
No,
You take
that
up
is-
the matter in Srinagar.
that is-
What
that is
happened
why
to
I'm
this
before-
proceeding? And this
That
is
is why I'm
only
before the court.
a DV proceeding and a proceeding. These are both two different proceedings.
Yes, Lord.
Different
Different.
proceedings.
Then
The section.
These are different.
Different.
Yes, my lord. These are
Then-
different proceedings, my lord. But my lords, may kindly see the what she has been doing here. Firstly, she approached the police station in Srinagar without any relief. Then she approached the concerned magistrate in Srinagar, my lords. Her
that
domestic-
also without any relief.
No. She was granted relief, the interim protection, to the tune of 17,000 initially. Then that was slashed down to 8,000. Apart from that, 4,000 was directed to me to pay as a rentals to her, which I have been paying regularly till it was lastly dismissed in the year 2023, my lord. Then she
Why
filed
was
a
it dismissed?
in the year 2023, my lords. Firstly,
Why was it dismissed?
for
Why was it
non-prosecution.
dismissed?
For non-prosecution. Yes.
Okay.
Then, my lords, she filed a restoration application. We did not made any objection to that because she being a non-native lady here, then her domestic violence petition was again restored back to the original number, my lord. Then again she abandoned the proceedings, my lord. Now again she has this
Now you
domestic
tell
violence.
me whether the institution, let's say that the DV proceedings is pending, whether during the pendency of a DV proceeding under the DV Act, an FIR for 498 cannot be filed.
That can be filed, my lords. That can be. But my lords, what my point is, where there is a harassment, where
We'll have
there
it
is,
at 2. We'll have it at 2. It's 1 o'clock. We'll have it at 2.
please, my lords.
IPCs.
Yes.
Yes. Mr. Gonsalves.
Please, my lords. My lords,
Hmm.
apart from this point that it is to be ordinarily tried by the courts or it is to be lodged where the offense has taken place, I am fortified by the provision under section 177 CRPC, which says that ordinary place of inquiry and trial.
One.
Every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. This is my first point, my lords. Now, my lords, I'll be going to the other very important ground is the delay in the FIR, which has occurred in lodging the impugned FIR. Before that, I want my lord's kind attention towards page number 23, relevant from page 24, which is the impugned FIR, my lords.
Page?
Page 24 is the relevant, my lords.
Just a second. Just a second.
This is the FIR, my lords. In order to...
Mr. Hazim, just a second.
Please, my lords.
You were referring to 177.
177, my lords. This is a basic concept of law. And in fact, my lords, what my submission is that even if a judgment is there, that cannot override the statute, my lords. This is what I have learned from the criminal jurisprudence, my lords. This is my one point. My second point, my lords, is the delay in the FIR. In order to fortify my view, my lords, am I audible, my lords?
Yeah.
Yes. In order to fortify my view, my lords, it's necessary that we will go through the contents of the impugned FIR, my lords. May I, my lords?
Some sound. It's
My lords,
breaking.
yes, my lords, there's snow going on here. Maybe that causes disruption, my lords.
It's very difficult.
My lords,
Why don't we fix the matter tomorrow or Monday?
my lords,
you can come
snow,
down.
my lords, snow is
It's very
going on here.
unstable.
Maybe
The
that
connection is
causes
unstable.
Yes.
my lords, snow is going on here. Maybe that causes the disruption, my lords.
I'm not getting your voice very clearly.
My lords, snow is going on here. Maybe that causes disruption, my lords.
Okay. We'll
Yes,
have
ma'am.
it on. We'll have it on Monday or Tuesday, whenever it's convenient to you. We
My
can come
lords,
down and we can.
my
we
lords,
can finish off the matter.
meteorological department is saying that this will be for a week. Let it
No,
be
you
fixed
can come
after a
down.
week then.
You can come down here. We can have the matter then.
Then, my lords, we are going through these vacations in the month of January. If it is possible to list it in the month of January, then after 5th, because High Court of Jammu and Kashmir will be going on vacation from 5th of January, my lords.
Another thing, let's consider we'll consider your delay also, the plea of delay.
Yes.
But what I find on reading the FIR, basically I'm only concerned with the FIR.
Yes, yes.
The ingredients of 498A are prima facie for drawing a satisfaction as on date is made out.
Right, my lords.
So, in that view of the matter, why should we not allow the investigation to go on?
For the reason, my lords, that there is the abuse of the process of the law, my lords. And once there is the abuse of the process of the law, my lords, for the reason that you are approaching, am I audible, my lords?
No, that DV case, unfortunately, I'm not very...
No, I'm not on that, my lords. What I'm on, that she is herself narrating that she went to the Arunachal in the month of November. And in April, she is filing a complaint. So from
And
November,
was she living with you during that period of time?
no,
From
No,
March
my
onwards?
no, my lords. She is herself narrating in the impugned FIR that she went back to the Arunachal in the month of November 2023, my lords. So from 2023 up to March 2024, till the time of the lodging of the impugned FIR, she has not stated as to why she has not approached the concerned police station, my lords. So, my lords, this being an afterthought. So on this point, I am fortified by the Bhajan Singh's case, my lord. Bhajan
Yes, what
Lal
is
case.
the reason for your delay?
Yes, my lord, after filing my domestic violence in Srinagar, so matter was taken up and my statement was partly recorded, cross-examination partly recorded. So thereafter, I have some financial difficulties and I came back to my.
But he was giving you finance.
No, my lord, till now 2,70,000 area is pending. So far, he has not
Wrong
paid.
statement, my
Yeah,
lord. Wrong statement, my lord.
Mr. Hazim.
Please,
Hazim,
please.
I'm doing.
Pardon, my lord.
And my lord, I have a 4.5 months years old son who is now with me. And husband was also assured to pay the arrears of maintenance of 8,000 and including 2,000 for 4,000 for rental, and that also not paid.
Okay, but why didn't you immediately come down then to Arunachal Pradesh and
My lord, just I was to and fro from Arunachal to Jammu and Kashmir because I have to
then
attend.
okay, if you are to and fro and this is the allegation, why did you not institute a proceeding earlier?
My lord, the allegation that whatsoever commission of crime was continuously committed
After
by
March,
the
there is no
petitioner.
continuation after March.
And yes, my lord, I have.
When did you leave the company of the petitioner?
My lord, there was so many threatenings from the petitioner husbands. Even I have launched complaint before the authorities of Muslim communities, which I have included in my petition, my lord. Page number 65, my lord. I have also made complaint before President Masjid Maula Abu Bakr. And their decision also in favor of me, my lord. They have also found guilty against my husband, my lord.
Then what was the trigger of point to lodge this FIR?
My lord, I have so many problems there in Srinagar, Jammu and Kashmir. I have no any accommodation was provided. One rent accommodation provided, but husband has never been paid the rental
You
amount.
lodged this FIR on 1/3/2024.
Yes, my lord.
The allegations go back to
Subsequently, my lord,
19,
petitioner
20.
husband was subsequently committed cruelty against me. And even he has also assaulted me here in my parent home at Royang, Arunachal Pradesh. Once he was visited here in Arunachal Pradesh, in front of my mother, she was assaulted me. That I have written in my FIR.
But these
So
are all
commission of
incidents
crime was committed.
These are all incidents of 2022.
My lord,
23.
2022, 23 continuously he has
But
harassing me.
And okay, you came back in November 23.
Yes.
Then what made you wait till March?
My lord, my
Your
husband,
explanations
my
very
husband has taken lots of excuses and he asked me to settle the matter mutually. And so many times.
Now some problem I'm not being able to follow because I don't get something, it may cause prejudice to the person. We'll have it in January. Let him also come down.
Yes,
the hearing be here. When can you come down, Mr. Hazim?
After 5th of January, but before
Give me a
25th.
date. You give me a date.
Let it be 8th, 9th, 10th, 11th, 12th, because we are on vacations.
Heard Mr. Hazim. You are Mr. M. Hazim, Mohammed Hazim.
Mohammed Hazim Qureshi.
Mohammed Hazim Qureshi, learned counsel for the petitioner. Also heard Mr. So-and-so, respondents ka naam. However, on account of certain audio malfunction, the submissions made by Mr. Qureshi was not clearly audible. So accordingly, Mr. Qureshi has submitted that the matter be fixed on 9/1/2024 when he would be present before this court in person to make his submissions in the matter. The prayer is not objected to by the learned counsel for the respondents. accordingly registry to list this matter again on 9/1/2025 for 9/1/2025 for admission, no?
Yes, yes, my lord.
Yes, admissions for admissions.
Interim, my lord. Interim, my
Interim
lord.
order passed earlier to continue till the next date of this.
Thankful, my lord. Highly obliged, my lords.
Much.
Yes, what happened?
My lord, this case, there's a subsequent development, my lord. I filed the additional affidavit on 19/11/2024, my lord. The appointment which is subject matter of the challenge and recruitment that has been cancelled during the pendency, my lord. And it's called for.
When 1911?
Yes, 19/11/2024. Additional affidavit filed by respondent 1 and 2. Considering the representation submitted by the petitioner.
Okay. Yes.
Lordship, after there is an interim order staying the appointment. In the affidavit, he have said that the private respondent has joined, but till that there is no such joining report.
No, but today they have cancelled that appointment and they have said that the post would now be put up for would be re-advertised.
Yes, Lordship.
Then
Now,
what is left?
now the challenge made is the private respondent is not qualified for this post.
That is why they have accepted your prayer.
Yes. Now I am qualified. I have been kept in the panel list.
They
Now-
have cancelled the entire selection process.
In
You
respect,
make a challenge to this. Where is that cancellation order?
Cancellation order is at page 199.
199.
Annexure 2.
So you make a challenge to this, Mr. Abing.
Lordship, there will be another interesting.
help it. Can't help it.
Lordship, another interesting.
Because see, one factor.
Lordship.
Or we have to now, if we had considered the matter and
Lordship.
we came to a conclusion that no, that lady is not entitled
Lordship.
for an appointment, private respondent.
Lordship.
So we could have directed.
Lordship.
But that very issue which we could have adjudicated is no longer before us.
Lordship, that's why, Lordship, we have filed one IA for additional affidavit in this.
You will have to challenge this, amend your writ petition, challenge this, that will finish.
All right, Lordship. Now,
Because what I'm saying is, if this is not revived, if there is no challenge to the cancellation, how can because once that lady is appointed,
Lordship.
the appointment occasion when? Before the interim order or after the interim order?
Before interim order.
Interim order. You are for the private respondent.
Yes.
Lordship, there is no
Where
appointment.
is the
order.
appointment order?
Appointment order, I have a joining report, my lord.
Oh, joining report, okay, fine. Where is the appointment order? When was the interim order passed?
25/6/2024.
25/6/2024. When was the joining?
On 21/6.
Oh, wow. Coincidental or
This is my
appointment? Okay, show me a letter.
Because of the subsequent development, we could not file our.
21/6/2024. So, Mr. Abing, there is another technical problem.
Lordship.
Now that rightly, wrongly, that lady was appointed,
Lordship.
that select list lost its validity. Okay, now, okay, fine, you were here. We could have considered if that aspect of the matter was alive. This appointment was continued, we could have interfered with that and directed that you are the next man, you give it to them. But now they have cancelled, rightly, wrongly, they have cancelled the entire selection process.
Lordship.
Now, for us to come in, you will have to bring in, you'll have to invite us.
Lordship.
Now that invitation will come in only when you,
Lordship.
I'll keep this matter pending. Either you amend it or you file a small short writ petition assailing this, that's all. Tag it up together, hear it.
Lordship. Lordship. Then Lordship will amend the petition. Let the matter will.
I'll keep it pending, no
Lordship.
problem, because
Lordship.
you have a right.
Lordship.
And the action of the respondents also reveal that they were not up and doing it. The husband of the petition respondent,
Yes.
who may have.
My lord, we do not have, my husband does not have any role. He only
He was a
scrutinized
committee.
the documents. He was
See,
scrutinying.
bias, concept of bias, it's not how much deep water you are. It's just indicative. That is enough.
I only.
And with this relationship, you need not even prove bias. Bias is automatic. And the order says, the affidavit says something more, additional affidavit.
No, my lord,
And that is the ground they have cancelled it.
it is subject to challenge to my opinion also, because without giving me any notice, my lord.
That is why, Mr. Pichai, once still, that is not put to challenge.
No.
On the prayer of Mr. A. Apik, learned senior counsel, not objected to by the learned counsel for the respondents. The registry to list this matter again when? Earliest. Next week. When should I put it? By when can you have your petition, or immediately after vacations if you want?
After vacation.
But they'll, if they issue an advertisement, that will complicate the matter further.
Lordship, in this letter, they have said that we are seeking clarification from
MNC, madam.
MNC, and they have not
List this
retaken
matter
it.
again on 8/1/2025.
Lordship.
But Mr. Abang, if you want us to come in, come back first to us.
Lordship. Lordship. Will be before that, Lordship. Right.
None appears for the petition on, oh, you are there.
Yes.
PP?
As per the interim order of the Dishonorable Court, I am executed on 6th of this month, Your Lordship. And giving a statement to the
No, we
before the
want
IO.
Madam Ade, have you got the case diary?
Your Lordship, I'll just call up Mr. Atta. He's
Okay, fine. We'll have that. Both are same.
both are same matter.
Same. When you are ready, just tell her.
Yes, sir. In item number 18, Your Lordship, the fresh step was to be taken, Your Lordship.
Not taken.
I've just informed the council. He was with me this morning stating that he'll take steps today, Your Lordship. But then I'm not able to find him in the court today.
Who is the counsel?
Jitalo.
But none has been appearing for
Since
the last
many,
around
yes.
3-4 days.
In fact, on two
We'll wait for
occasions-
some time. If it doesn't come in, we are dismissing it.
Okay. Deep note.
On last occasion, this court directed to clarify the sentence is spent.
What happened?
Now, punishment is for 10 years. As on yesterday, as on 11/12, he spent 7 years, 5 months, 3 days.
Only
Yes, still
pending.
2 years, 7 months left.
And why was this thing that he had completed 10 years?
Your Lordship, date of arrest was 16/10/2014, Your Lordship.
16/10/2014.
2014.
Conviction?
Conviction is of 26.
No, it's 6/06/06, 2019.
19, conviction,
06?
06.
2019.
Okay. Now, After arrest, he was in, for the 5 years, he was behind bars.
That was not,
Then you clarify that. If that
so
be so,
regarding that instruction was sought for.
then,
So
so that period, you might have got it from the jail superintendent.
Yes.
So, but what about the police period, before the conviction?
It
before the
it
charge?
was already set up during the conviction time, and it was it is 1 year, 10 months, 28 days.
Okay. So, madam, you have not.
No.
So we'll have to
So
hear this.
we'll have to.
She showed the clarifications that it was the sentence appointed was elapsed, but it's still
So this matter can be listed for hearing, Your Lordship.
still awaited. Service report in respect of R2 is still awaited. As per office note, second page of office note.
Informant is the wife of the accused, Your Lordship.
Also, seen the office note dated 5/10/2024. The unserved notice has been returned back to the registry. So accordingly, petitioner is directed to take fresh steps for service of notice upon the respondent number 2.
Your Lordship, I'm for amicus.
Amicus. So who will take that step?
Registry, Your Lordship.
You are amicus for the
Appellant.
registry is directed to issue fresh notice upon the respondent number 2 through the jurisdictional police station. Officer in charge of the jurisdiction of the jurisdictional police station. Also, steps be issued within next 3 working days. Full stop. Mr. Kato, G. Tado, learned additional public prosecutor has submitted that the petitioner has not suffered imprisonment for 10 years as in terms of the judgment dated
6/6/2029.
6/6/2019 and has only completed
7 years, 5 months, 3 days.
7 years, 5 months,
3
3
days.
days as on
11, yes.
11/12/2024. Accordingly, registry to list those matters again after 3 weeks, along with a report on board or a report with regard to the status of service of notice upon the respondent number 2.
Obliged.
Obliged.
Yes, Mr. Eric, have you got the?
Yes, Your Lordship, CD we have received, Your Lordship, here the IO has stated that the investigation has been completed, Your Lordship, and he is not required for custody interrogation.
Okay. Heard Mr. T. Gaidi, learned counsel for the applicant, also heard Mr. T. Lete, learned additional public prosecutor appearing for the state. The present application has been instituted by the applicant praying for grant of anticipatory bail under section 482. Both are same, no?
Yes, arising out of same FIR.
82 BNSS 2023 in connection with Itanagar PS case number 223/2024 under section 126(2)/118(2)/351(3)(5) of the BNS 2023. Also, this court had white order dated 4/12/2024 allowed the petitioner to enlarge the petitioner on interim pre-arrest bail of rupees 10,000 with surety of like amount to the satisfaction of the arresting authority. So, in terms of the direction so passed by this court, the applicant had appeared before the investigating officer on 6/12, both 6/12/2024, and his statement was recorded. So, today, when the matter was taken up, the updated case diary has been placed before this court along with a note. Note of the.
Yes, Your Lordship. He said that here, you know, in the first page only, it is clearly mentioned, Your Lordship, by the IO.
and along with a forwarding note of the IO, wherein it has forwarding note dated 6/12/2024 of the IO, wherein it has been submitted, it has been stated that the investigation of the case is complete, and accordingly, the bail granted be made absolute. Full stop. In view of the above position, the interim pre-arrest bail as granted by this court while order dated 4/12/2024 is made absolute, subject to the following conditions. The applicant, applicant shall cooperate with the investigating officer in the event any further particulars or materials is so required from him. उसके बाद ये 2 करके ये 3 वाला लगा दीजिएगा. Order dated 4/12/20. दोनों में same. Bail application stand disposed of.
CD may be returned here.
The CD, so furnished is returned to Mr. T.A.T. Learned, additional public prosecutor.
Much obliged.
Number 4/12 का order है उसमें से मान लीजिए. 28/29 same order. खाली 2 बार मानना पड़ेगा. 28/29 disposed of. Oh, this is 16 of order. Okay, 16. Okay. Sorry. एक ही में है. Okay. 16 and 17.
16 and 17.
16 and 17. दोनों डिस्पोज. नहीं देखिए. 18 तो हो गया. हाँ. Yes. Why are you not appearing? You're not interested. Tell us. We'll not continue with the matter. Last 3-4 days you are not there. 4 days.
Your Lordship, on the previous date, we did take steps, but it was not complete. So we are praying today for taking.
You have already been permitted to take fresh steps. You have not taken.
We're making one more prayer to take fresh steps, Your Lordship.
By tomorrow. We'll have the matter otherwise listed on Monday and we will finish it off.
1 week, Your Lordship.
The learned counsel for the petitioner submits that he would take these steps in the matter latest by tomorrow, that is 13/12/2024. So, in the event such steps are taken, the registry to issue notice for service of notice upon the respond number 2 by registered post with AD as well as by usual process. So, in the event such steps are not taken by 4:30, what time the registry closes?
3 o'clock.
3 o'clock tomorrow, that is 13/3/2024, registry to list this matter again on 17/12/2024. And mind you, if you take these steps on Monday also, it will be a problem for you.
Deeply obliged.
Okay, please allow. Sir, I am against you. How can the public property damage be compromised by somebody who is not even there? And what is this compromise? Nothing.
Because the doctor who has the complaint.
Doctor ask him to go and make statement before the trial court. Then you will be otherwise also. But this public, because if I lay down, if I do it today in this case, then any public property, I'll have to be following that order. It will be a law laid down. Why should I? The ambulance damage.
Yes, that was already repaired.
But that is not the answer, Mr. UPPP, or what is that act called? PDPP Act. Then is it written in PDPP Act that once you repair the public property, the criminal element is no longer there? See, it's not a case of 100 rupees or 200 rupees damage. That's not the way of looking at it.
Yes,
It's damage to public property.
Yes.
We find it very difficult.
Lordship,
Today, unfortunately, I don't know, all the washing matters are not.
I don't know, Lordship, this is because this is not a very heinous.
No. It's, we will not, if you want to press it, you press it, I'll hear it and I'll dismiss it. Or you can have it after the vacations, try.
Then after vacation.
No, on the prayer of the learned counsel for the petitioner, registry to list this matter after vacations on a date to be fixed, right? After the ensuing winter vacations on a date to be.
Most of that.
Mr. Tagum, response R6 is not served till now.
My lord, there's a subsequent development, my lord. This, the impugned transfer, the challenge, my lord, subsequently government, they are kind enough, they modified, my lord, on a
Okay.
medical ground, my lord.
None appears for the petition on, on call. Mr. Tagum,
Serial number
learned
1.
standing counsel, education department submits that the transfer of the petitioner impugned in the writ petition mein likhega, in the present proceeding has been modified by order dated 2/12/2024. Full stop. The petitioner now has
Issued on
been
11.
2/12/2024, huh? Issued on, we'll say order dated 2/12, we'll say, whenever it's issued, 2/12/2024. And the petitioner has been now retained as BRCC Dapori Jog Upper Subansari on medical grounds. Full stop. In view of the above position, no further adjudication is called for in the present proceeding. However, there being no representation on behalf of the petitioner, the present writ petition stands dismissed for non-prosecution. Full stop. ISAMN. In view of the orders passed today in WPC number 537 bracketed AP 2024, no further orders is called for in the present interlocutory application and the same stands closed.
Deeply approved.
I kept it like that. If he wants, if he has any grievance,
My lord.
let him come back.
My lord.
May your lordship. Your lordship, we have taken steps. We have taken steps.
Where? Which one?
No, 23 and 24.
Oh, I thought you had very fast taken steps.
No, your lordship.
23 and 24.
Yes. As per the direction.
Why so submissive? You should come up and say boldly. Court may say 100 things. Why do you get bogged down by that? Never. Whom did you take steps upon?
State Commissioner Food and Civil Supply. On the previous date, we were directed by the Honorable Court to array State Commissioner as respondent number 4, Your Lordship.
That has been permitted.
We have filed IA. In lieu of that order, we have filed IA with the prayer that respondent number 4 may be arrayed as State Commissioner may be arrayed as respondent.
Did you give him a notice about dependency of the present proceedings?
No, Your Lordship, we will take steps on that regarding them. And Your Lordship, we have another prayer that we have amended the contempt petition, Your Lordship.
Amended?
Amended, yes, Your Lordship.
You want to amend?
Yes, we have already filed it as well, Your Lordship.
Where? It's not here.
We have filed it.
What do you want today?
We have basically two prayers regarding the IA, Your Lordship. First is allow us to inform the court that we have taken steps regarding filing the IA.
Okay.
Yes.
That means steps is with regard to filing of the...
Filing of the IA, yes. Your
Okay.
Lordship.
I got it wrong. No problem. So the present interlocutory application has been instituted, praying for impleading. You are trying to implead whom?
State Commissioner Food and Civil Supply.
Impleading
Mr. Amjad Tak.
the impleading Shri Amjad, they pleading the present incumbent in the post of Commissioner, Food and Civil Supplies Department, Government of Arunachal Pradesh, as a party respondent in the connected contempt case being contempt case number 5 bracketed AP 2020-24. So, I have perused the averments made in the writ petition and also heard the learned counsel for the applicant. So, on consideration, it is found that it is the incumbent who is now being incumbent. Is found that the person now sought to be pleaded as party respondent is the authority who would have to implement the directions passed by this court while order dated 14/6/2023 in contempt case number 8/2023. So accordingly, the interlocutory application is allowed and the petitioner is permitted to implead. उसको अभी थोड़ा एक नीचे में ये A to A मार दीजिएगा, आएगा पेज 3 A to A, हाँ, full stop. सब interlocutory application stands disposed of. Contempt में लिखिएगा, contempt case number 5 AP 2020. In view of the order passed today in IAC number 251 AP 2024, impleading वो जो same आदमी का नाम बीच में यहाँ पे दिखा देगा, so and so as party respondent number 4, comma, petitioner to file amended cost title incorporating the respondent number 4 in the file a fresh cost title only.
Yes, Your Lordship.
2-3 pages, huh?
Yes, Your Lordship.
So and so, full stop. Petitioner raised upon filing of the cost title, upon filing of the appended cost title by the petitioner, comma, the registry to issue notice upon filing of the appended cost title, the petitioner shall take steps for issuance of notice upon respondent number 4 by way of registered post with any steps within 3 working days from today. Registry to list this matter after 4 weeks on a date to be fixed by it.
Deeply obliged.
Yes, madam.
Please, Your Lordship.
Hmm.
My lord, there has been a subsequent development in the case.
Today it seems to be a day of subsequent development.
Lordship, our prayer in the writ petition was that they should assess our standing assets over the land. There, from the land department, there has been some, they've come and they've measured the land, but they've not told us as to whether this
Have they
compensation
filed
would be
affidavits
given.
in the matter?
No, this is the
Yes.
second time that it's come up.
File your affidavit.
Today, Lordship, it was for consideration of interim order. Since they are doing that, I don't think they would.
You don't disturb them, let them do it. We'll not come in. We'll
Yeah.
see.
Yes.
We'll ask Mr. Kamduk to get his instructions in the matter.
Yes, Lordship, may I pray one thing, Lordship? Even though they have come and they've measured the land, we are not sure whether on the basis of that, they are going to give us compensation.
Madam, we'll
So-
just ask for the latest update from Mr. We'll fix a date.
Yes.
On that, he will receive complete instructions and he'll place it before. the-
Yes, can it be at the end of next week?
No problem.
Because by then we'll know something.
Just after New Year, madam.
No, you have quoted, we have quote till 24th, 25th, no, 24th.
24th.
24th. So you can have it on 23rd also, you get your instructions.
My lord, in fact, after 22, my lord, I'm.
Then we'll have it on 21st,
Yes,
20th,
Lordship.
20th.
Yes, Lordship.
20th.
30th.
220.
That,
Miss
Lordship,
Emmett.
sorry.
Instruction, in fact, my lord, if it can be this collected for the deputy commissioner, my lord, because the land allotment, my lord, it is done by the deputy.
No.
commissioner.
The
Allotment is not in
assessment
question.
has to be made by whoever makes it, you are the king. Whoever makes it in the state, the director of land management is the king.
Yes.
So he will know everything. So we want it from him. Whoever is made that, you get it.
Yes, ma'am.
So DC will say, I don't know who did it, but you will know who did it. You get it.
Lordship, sorry.
No, please.
Additionally, I'm also praying that the issue of prayer for interim may be kept open
Okay,
till the
fine,
next step.
we'll do that. Mr. T. come to Learned Council for the Standing Council Land Management submits that he be given a week's time to complete his instructions in the matter and place the same before this court. Full stop. Prayer is not objected to by Ms. N. Dangan, Learned Council for the petitioner. Full stop. Accordingly, registry to list this matter again on 20/12/2024, on which date Mr. Kamduk would receive his instruction with regard to the prayers made, with regard to the claims made by the petitioner in the present proceedings. Full stop. The prayer for interim direction shall be so considered on the on instructions being so received by Mr. Kamduk in the matter. So I have kept it open.
Yes, obliged, Lordship.
None appears for the petitioners on call. It is seen that on the last date of listing also, there was no representation, and accordingly this court had observed that in the event there is no representation today, for adverse representation today, the present petition would be dismissed for non-prosecution. Also, there being none, there being no representation on behalf of the petitioner even today, the present revision petition stands dismissed for non-prosecution. Interim orders, if any, shall stand vacated. तुम लोग जो है वो गुडली लो. Dismiss. Oh, what is that? Madam, contempt case dismiss. Contempt case में भी लिख दिया non appears dismiss. Contempt case तो दीजिए तो. इसका बोल दिया. Important. Contempt में भी separate order मारना है. IA भी है, देख लीजिएगा. IA 2 IAs. In view of the order passed today in WPC number so and so, no further order is called for in the present interlocutory application. Accordingly, the same stands dismissed. मैडम एक बार देख लीजिएगा कहीं डिस्पोजल ऑर्डर है क्या? Yes, you can leave. Please.
My lord, petitioner, he was appointed as contingency staff in the hydropower department, my lord, in the year.
Is appearing for the private respondents?
Yes, sir. Yes, ma'am.
Okay, we know, but what is your case?
My case is that, my lord, in nutshell, my lord.
2001, your appointment. Okay.
Yes, my lord. And in the year 2013, my lord, there was upgradation of some of this.
You say that upgradation was made, one, that they were your juniors.
Yes, ma'am.
Two, it was done without any trade test and all those things.
Yes, ma'am.
Right?
Yes, ma'am.
That is your case.
That is my case, ma'am.
But they in their affidavit say, no, we have done it in the manner required.
My lord, I was not called for that trade test, my lord. Had it been, my lord,
Yes,
I have
Mr.
still
Madam, you will be answering.
Yes, Lordship. Lordship, we have denied his seniority also, Lordship. We are saying
Said he is 21.
Yes. Lordship.
But tell me, where is that minutes? Minutes were called for.
And Lordship, actually that upgradation also it depends on the person's skill trade also.
Madam, whatever it is, this court had by an order, I saw it yesterday, call for the minutes of the meeting by which the private respondents were promoted. Yes, which is the order?
My lord, although there is no minor of the this.
No, they are
But-
the 23/11/2022. 23/11/2022. 23/11/2022. Huh. Shall produce the concerned file of DPC proceeding of 23/3/2023, annexure 5 to the affidavit in opposition filed by the respondent number 2. Annexure 5.
This screening committee.
Whatever it is, it may be a screening committee also. Annexure 5 to the respondent number 2. Annexure 5. And where are the appointment orders of the private respondents? It was somewhere here.
Yes, my lord. My
The petition, it is there.
DPC.
yes.
Just a
Screening
minute. Just a minute.
is here. Record is here.
Okay. So it was on the basis of that screening report, committee report, that these people were promoted, right?
Yes, doctor.
Okay, show me what is that.
Yes.
And was his case considered?
Possibly, he is not in the list, doctor.
Why?
In the
How many posts were filled up?
trade-wise, this is.
So what is his trade? What is your trade?
It's just a casual,
Worker,
worker.
All
unskilled.
even
Yes.
even the private respondent, my lord, they all are casual worker, my lord.
Okay, not skilled workers.
So, my lord.
There
Show me,
were
ma'am.
somewhere casual operator, lots of, some thread is there. The first page is the screening, lots of. The first page, lots of. Earlier page. No, not that, lots of.
Screening committee. DPC type proceeding report. So you mean to say that only it was limited to skilled people?
Yes, and lots of what we have said in our affidavit is that, lots of. The case of respondent was 6 to 9, lots of. They were considered through DPC type screening committee. Appointed based on their requisite professional qualification, age per recruitment requirement of task in the department.
So, okay, why was the petitioner considered and why was he not considered and rejected? At least that consideration should have been there. He says that these people are junior to him.
That
Right?
is his, that
Yes,
is
madam.
his
Even
claim.
my lord,
Also,
it is the
Show me,
admitted fact, my lord.
just show me that they are not junior but senior to him.
lots of, but in age per record, what we have said is that in age per record in Pangin EM division where he is, he doesn't come to the seniority list, lots of. Age per his claim, lots of. What we have said is his claim to be senior most is not correct. Lots of. And then
He was also skilled labor. In 2001. Okay, the people that you have recruited now, that is in 2013.
Yes.
So therein, what was their seniority position vis-a-vis the petitioner?
Yeah, I have said Lordship already.
That they are not from the same division.
No, same, not same division, some are. And then Lordship is depends on their thread also. In which thread they are
Madam,
expert.
give us that breakup, how you have done it. What are the names of the respondents, private respondents?
Private respondents, Lordship.
Tanin is there. Tanin is there. Kamal Boro in that list.
Private respondent, Lordship.
Hmm.
If Lordship come to my affidavit.
Yes, madam.
Second affidavit, Lordship.
Dated,
That
filed by?
filed by respondent to again.
Okay. Superintending engineer. Page 4, second paragraph. Madam, where is that material?
Criteria, Lordship. Lordship.
He is not in Pangin. He is in Pangin. You are in Pangin.
No, my lord, now I have.
No, then.
Yes, at that point of time, my lord.
Pangin.
Yes, sir.
Then you were handed over to some other.
I was initially, my lord, this posted there at Alo, and I was handed over to this Pangin division. By
And that
Alo,
is
my
where
lord.
the promotions.
My lord, may kindly come to take up my writ petition, my lord. From that, it will be clear, my lord.
Okay, forget it. No, you come.
And then, my lord,
Okay, tell me how you moved.
Before that, my lord.
No, just tell me how you moved. First posting when? 2000?
My lord, I was initially appointed.
2001, 17/5/2001, I suppose.
1905.
19/5.
Yes, my lord. 2001.
Where skilled?
Yes, my lord.
Skilled labor.
Yes, my lord. My lord, this is in fact not disputed by the state respondent. my
Okay,
lord.
fine.
If when, my lord.
We'll come to the dispute.
Yes,
Let us
yes.
get the facts.
Yes.
Skilled labor, where were you posted? Engaged?
Alo, my lord. Initially at Alo.
Office.
Yes. Alo division office, my lord.
Alo divisional. That is means the executive engineer.
Yes, my lord.
Officer. So then,
my lord, I was transferred to Pangin, my lord.
when?
My transfer to Pangin, my lord.
Mr.
My lord.
Mr. Contempt.
Yes, my lord.
You, this will not do like this. You give me a chronology.
My lord.
On the date when you were appointed, skilled labor, then transfer. When you were in Pangil, where were you working? Where were these private respondents working? How they came up? Why you were not considered? Those material with regard to paragraphs, give me. Then only we will consider. When? Tomorrow?
Yes, my lord.
Tomorrow?
Yes, my lord.
Can you give me that, madam? Tomorrow, Monday, whenever it's.
Tomorrow,
Let him give that details, otherwise it will be difficult.
Tomorrow, my lord. Because my lord, otherwise my lord.
Madam.
Monday, tomorrow
Ma-
I have some.
Ah,
Let it be
can't-
tomorrow, my lord.
it cannot be. Madam's convenience will also have to be seen. So now if I ask you a question, you take 5 minutes, I'll lose interest.
My
So I
lord,
don't want that to happen.
My lord, in fact, where I was posted and where now I am posted, my lord.
I'm
My-
not on
where-
that. I'm not on that. They have taken a plea that the persons who have been promoted are not posted where you were
No, my
posted.
lord. From their document only, my lord.
Oh, you just give me a chart. That will do. Monday. You give me that chart.
Yes, ma'am.
Okay.
Yes,
And
ma'am.
don't make it haphazard.
Yes, ma'am.
Simple.
Yes, ma'am.
Then show me that they were also in the same seniority list where you were also there.
That, my lord, it is there in their affidavit.
Okay,
itself, my
fine.
lord. Even the seniority list, my lord, they have annexed
No, no,
their
no.
affidavit.
Can you just make the points pages clear?
Yes, ma'am.
You
I'll do
leave
that,
it
ma'am.
with her tomorrow.
I'll do that, ma'am.
Leave it with her tomorrow.
Yes, ma'am.
I'll come prepared. Monday we'll finish up. the
Yes,
matter.
ma'am. Yes, ma'am.
Because I got confused. I wanted to get it because this places,
Yeah.
maybe I'm also not very.
Yes, in fact, I am not also very much clear about his this where he was posted. my lord.
That is
In
required
fact,
because
my
this plea is
other
required.
rest of the facts, my
No,
lord.
no, no. Because the ones they have taken a plea to that extent, we'll have to clarify that also. No? Ms. Ete may have a point there, but you will have to show that she's
Yes,
does not have a point. Ah.
I'll certainly do that, madam.
Ah.
I'm also still confused, my lord.
Ah. And you want the poor court to. Ah. I tried yesterday. Then I found there is a gap. I was not able to close the gap. I thought I'll do it here.
Yes.
But unfortunately, no. So you give me that.
Oh.
Otherwise, this I could have.
Most of my lord.
Madam, you are an officer, as an officer of the court, not as a government.
Yes, Lord.
You also just see. It seems that there is some lacking somewhere. If he's entitled, we'll protect everything, we will give him also. But
Agreed.
just check up. Because once you say he's not there, then you say his seniority. Okay, if his seniority is 21, what are the seniority of the others? Okay, if the others are not of the same trade, what are their trades? Where were they given? Madam, please.
Lordship.
Your that DPC like minutes is not helping.
Yes, yes, it's plain sake.
This is the same matter, my lord, in the last occasion, my lord. I'm so obliged, your lordship. Lordship, my lord, have got the opportunity to, my lord, revisit the provisions of the law, my lord. That lordship was on the last occasion, my lord, on law point, my lord, I have to make submission. Basically, my lord, a law point is very clear, my lord. Admittedly, my lord, the sample was collected within time. It was sent to the government analyst, and government analyst, my lord, they conducted the test within the stipulated period as required under Rule 45 1, my lord. And my lord, the partnership.
That book,
the last occasion,
drugs and cosmetic act. Yeah, quote me.
The last occasion they punished me. Answer for the petition.
It did not go with me. Just check up मेरा किसी को भेजिए तो मेरा रूम में जो कहीं पे नहीं मोटा किताब the petitioners had given us.
Books, drugs and narcotics.
यहाँ से यहाँ तो पूरा हाँ एक कंक्लूजन नहीं ये नहीं चाहिए यहाँ हाँ there was a fat book एक बार देख लो तो मेरे चंबर में कहीं पे
No, my lord, the very particular, my lord, the rules demands, my lord, it has to be published within a period of 60 days, my lord. Now, my lord, in our case, the report was, my lord, sample was collected on 22.
No, we get everything.
My lord.
2017, everything is fine.
My lord.
But you filed the complaint only in 2019.
My lord.
So the projection made by the learned counsel was that, see, by this time that batch it has might have expired.
No, my lord.
So where is that fourth component? Have you deposited in the court?
My lord, in that very certificate, my lord.
Thank you.
If lordship revisit
It's
the,
here.
yes, ma'am. So just for the, my lord,
No, Mr. Kato will go into it. But
yes, ma'am.
that four, it has to be made into 4 portions.
My lord.
So the 4th portion you have to give to the court. Then he can make a demand. That, see, I want a re-valuation.
My lord, that is in respect of when the proceedings, my lord, the investigation, that is one kind of investigation, my lord. The inspector has done one kind of investigations that has been
You
done.
were supposed to give me a note today. What happened? Yes.
My lord, that is the position, my lord. If we, my lord, revisit the, my lord, the section 23 of the, my lord, the Drugs and Cosmetic Act 1945, my lord, it is very clear, my lord.
We'll do one thing. You give me a written argument. Whatever you want to say.
My lord.
Give me a written argument by Monday. We'll have it on Tuesday and finish it up.
My lord.
We'll have it on Tuesday and finish it up. I understand what you're trying to say.
My lord.
Tuesday we'll finish it off. Right? When can you give it? Monday?
Monday.
Monday. Heard Mr. M. Kato, Learning Counsel for the petitioner at some length. Hearing remains inconclusive. Raised it to list this matters again on Monday. Tuesday. Yes. Tuesday. Ask Mr. Chakraborty to come online on that day. He did not come here. Come online. So we'll conclude that day. But you will also have to satisfy me.
My lord. My lord, that is the only crux of the case, man. What I have seen, man.
23.
20, my lord, section 23, my lord, after punishing, my lord, the report has to be, my lord, punished to the inspector or the who, my lord, they sent for the, my lord, the analyst. It has to be sent, my lord, within a period of 60 days after the Amendment Act of the rules, man. It is, my lord, 60 days. Within a period of 60 days, it has to be done, my lord. My lord, in our case, admittedly, this sample was tested within the period, my lord. And on the last occasion, my lord, the counsel for the other party, they submitted that it has no efficacy. It has already been expired. No, my lord, it is not correct. The tablet, my lord, is, my lord, having, my lord, the
span life.
Span life of, that is 2 years, my lord. From 2016 to 2018, my lord. It is clearly mentioned in the, my lord, the report.
Okay, but the report that was given, that was already acted upon.
My lord, report was submitted on 6/7/2017.
That was acted upon by the licensing authority.
After the expiry of 37 days, I have calculated now. The report was furnished after the expiry of 37 days.
So, what is the validity of
yes,
that
my
report?
lord. That is the one aspect, my lord. But however, my lord, the another things remain the same. The test was done within the period of, my lord.
Because they have placed judgments on record which says that the delay is also fatal.
My lord, yes. My lord, in fact, I have gone through the, my lord, the judgments of the Honorable Supreme Court and the other high courts, my lord. Admittedly, my lord, that is the settled position. When they, so therefore, my lord, at this stage, my lord, my submission.
No, you please. I'm trying to
my
get
lord,
something out from you.
Yes, my lord.
And you read 25(4) also.
25(4) is very clear, my lord. 25(4), it says that, my lord, it has to be, my lord, that has not been done, my lord. They have not, my lord, controverted.
Okay. You get it down, whatever you have in writing, give it to me. Monday, we'll have it on Tuesday. Don't go beyond Tuesday, any problem?
No, my lord.
You'll be here? 17th it will be. 17th. Okay? Any problem? Any problem?
No, my lord.
And ask Mr. Chakraborty to be here. Again? Yeah.
16, Tuesday.
भेज दीजिए इसको खाली आपका पास रखिए भैया मुझे दे किताब को ये रिटर्न आर्ग्यूमेंट judgments. एक फोल्डर में करके एक में बांध के दो कॉपी है मुझे दे दीजिए दोनों भी कोई बात नहीं गेट इट बैक एक फाइल में बांध के मुझे दे दीजिए अलॉन्ग विद द बाकी ये फाइल्स वहाँ भेज दीजिए
Right.